Ось можемо починати.
У нас насправді тільки 3 учасники зараз. Колеги, доброго дня. Пропоную почекати ще. Let's wait a couple of minutes for other colleagues to join us. Because it's the end of the working day, like official end of the working day. So maybe some colleagues just need more time. So we are in YouTube now, dear experts.
We live in
Okay, so let's start. I hope that during my introduction, other colleagues, more colleagues will join our session. So good evening, actually. Welcome to the second meeting of the UBA International Trade Law Committee. It's our pleasure to have this platform available to discuss the topic and the localization in public procurement with such high-profile experts. And I welcome our speakers, Antonella Salgueiro, legal consultant of the European Bank for Reconstruction and Development, Kseniya Smyrnova, professor of the chair of Comparative and European Law for the Institute of International Relations, Shevchenko National University of Kyiv, and Olena Radko, Counsel at the M&A practice at Asters. So we are going to have I'm sure we are going to have a professional and up-to-date discussion on the flashpoint, actually the topic that is very, very, very addressed in media and in expert cycles, but actually what we see, the demand for the analysis of this topic from the very legal point, and to see all pros and contras, and to see where is this balance between the objective and the content of the legal initiative. So let me remind that the draft law number 738 was released, the draft of this law was released at the late in late of June this year, and it provides for the local content requirements to be enshrined in the public procurement law of Ukraine as the compulsory requirements for tender procedures regarding machinery and products and public infrastructure. This raises an important issue. So whether localization is how does localization requirements look from the trade law perspective, from the EU law, from Ukraine's commitments under the Ukraine FTA and international and WTO actually law. And another block of questions we would like to address is what to do actually once the law is implemented. And what are the regulatory barriers, and are they barriers actually for business, for foreign business to comply with these requirements? And this is what we are going to talk about. So our first block, trade law block, we will call it, will be covered by Antonella and Kseniya. Then we will leave time for your questions, and then we will give floor to Olena to address actually these practical issues from the business perspective, from corporate law perspective, of the implementation, future implementation, in case the draft law is enacted. And Olena maybe will want to cover some tendencies on the draft law, how it is discussed now, what is the very late discussions within between the authors of the draft law. Because in the media, the information is available that the industry, actually some representatives of Ukrainian industry, they very encourage, of course, the draft law, and they encourage the activization of its enactment. So let's start our discussion. And I'm giving floor to Antonella Salgueiro. Antonella has quite an impressive experience in public procurement area. Antonella used to work at the public procurement division of the WTO, and now she works for the European Bank for Construction and Development. So the floor is yours. Thank you, Antonella, for joining us.
Thank you very much, Olesia, for the presentation. And it's really my pleasure. I'm really glad to be joining you today to discuss this present issue from a trade law perspective. So let me start by sharing my presentation, and please tell me everything is okay so I can already start. Everything is all right? Olesia, can you see it? Hello?
Yes.
Okay.
Yes.
Okay.
Okay.
So, okay, perfectly. So let me start by talking a little bit about the EBRD GPA Technical Facility Cooperation. So what is this? We have two, this has brought together two institutions, the EBRD, a financial institution, and the WTO, an intergovernmental organization. Both of these institutions are working together to encourage countries to join the GPA. I'm just going to go really fast on the slides because this is sort of introductory and it doesn't really add to the main issue, but I just really want to talk a little bit about the work that we are doing regards to the GPA in the area. So what actually the GPA facility provides significant support to countries seeking to accede to the agreement by providing or supporting three main pillars. The first one is capacity building. We provide capacity buildings, i.e. seminars, workshops, to develop the trade measures or capacity building regarding the trade measure or the necessary issues relating to accession to the GPA, and see that everything is okay, or the strategy required for parties to actually, or for economies to accede to the GPA. We provide country-specific technical cooperation projects. For example, it can be in the area of implementation of the agreement. It can be on the implementation of domestic review bodies, or mainly on, for example, working on the compliance or the legislation, or see that everything is in line for accession. And lastly, we provide accession negotiation assistance to countries wishing to accede to the agreement. So basically what we do is we assist along the way, step by step. We start, for example, helping to achieve observer status within the GPA committee at the WTO. We help develop the initial offer to be presented to the other GPA parties. We assist within the bilateral negotiations, designing strategies to be presented to the other parties. We provide legal compliance assistance or market impact assistance for the GPA final offer. And once after the accession has been achieved and the country or the economy is part of the GPA, we help with the implementation of the agreement. In this sense, for example, in Ukraine, currently there is an ongoing project on facilitating GPA implementation and capacity building of domestic suppliers. So in Ukraine, we have been really active ever since 2012, and there are many facets or many projects that we have been working in Ukraine, but I think the most important that I would like to bring up is the project with Procerement, which has saved Ukrainian government significant amount of public funds since it became mandatory in 2016. So let's go to the main issue of the discussion. I'm not going to go too much on the draft law 3739 because the audience already is really well knowledgeable about what these provisions actually amount to. But what I want to actually address is how these provisions or how these local content requirements actually affect international obligations or existing commitments of Ukraine vis-a-vis, for example, WTO agreements and specifically the GPA, which is the Government Procurement Agreement. So let's start with the World Trade Organization. The WTO is it's a forum. It has many roles. One of the main roles is it's a forum for trade negotiations. It's a forum that has supporting trade rules that govern trade across different jurisdictions. It also is a forum to settle disputes, and it's a forum where where trade negotiations and trade issues are really brought up for discussion within its different members. So in this context, we have different agreements. One of the main agreements is the General Agreement on Tariff and Trade. Why I want to bring up this agreement is because of the following. I have heard through the grapevine that among the exceptions that are being mentioned by the author of the draft law to actually justify these measures are the following. So within the GATT already, as you may know, have one of the main pillars of the GATT is the non-discrimination provisions. Notwithstanding, there are general exceptions to these non-discriminations, and within general exceptions are two that are the ones that I wish to discuss today. The first one is the government procurement exception, which is established in Article 38A of the GATT 1994. So what does this exception say? This derogation applies for purchases of goods and services as long as they are for governmental purposes, meaning that measures related to government procurement can be exempted under the national treatment obligation existing in Article 3. However, this article is not to be actually treated really lightly, and it's not to be broadly interpreted. In a previous case, the Ontario case from 2013, actually this provision has been discussed at large by the appellate body. And the result was the following. So what the appellate body said is that there are conditions where this derogation can actually be applied. However, we have to take into account the context of the case. So in this case, where this derogation has been mentioned, we had Canada, and Canada was already a member, was already a party to the GPA. However, the governmental agencies that was making use of these local content requirements was not included within the coverage of the GPA. So we have here an issue where the GPA actually was not applied. Why? Because the covered procurement was not actually included within the agreement. This is something that's really different from the current situation where Ukraine is part of the GPA, and there is an extensive coverage, and the items or the entities or the goods that are going to be covered by the exception are going to be goods and services and entities actually covered by the GPA by the GPA in Ukrainian's final offer. So that's something that, as I mentioned, it's really difficult to actually apply this exception to the current situation. Another exception that actually there's a lot of talk about is the security exception, which has proliferated during the last couple of years, including, for example, has been brought out by the US. But why the security exception is actually really difficult to apply, it's because of the following. Because if you are we need to actually define what the security exception is. So, for example, taking into account the paragraph 3, which is the one that is used for the exemption in this case, that could be used in the exception, it says that countries can take necessary measures to protect essential security interests taken in time of war or other emergency in international relations. However, when the panel in a case from 2019 defined emergency international relations, they mentioned the following: that the political or economic differences between member states are not sufficient to constitute an emergency in international relations for purposes of this subparagraph, meaning that there is a really narrow scope for what an emergency in international relations is. And also we have to take into account that usually security exceptions are applied vis-a-vis one member state or a region, but not to all of the member states or not against all other member states. So that's why the security exception will actually be difficult to apply in this sense also. So, or could be difficult to exempt the current law or under the security exception. So let's go now into the WTO agreement on government procurement. So what's the GPA? The GPA is a binding international agreement that promotes, it's first and foremost a trade agreement. What it does is promotes market access to the procurement markets of other GPA parties. In this sense, what it does is it increases the pool of competitors, it improves value for money obtained for each procurement, and it has underlying good governance features, for example, in regards to transparency, fair competition, and the prevention of corruption in covered procurement markets. So we're talking about covered procurement markets, not all the procurement market, but the procurement market that is actually covered by the GPA for Ukraine. And second, the GPA is a plurilateral agreement. What does plurilateral means? It means that not all WTO members are parties to the GPA. Only those that voluntarily decided to accede to the agreement. And we have seen over time that there is that the membership has increased over time, as we can see here. Currently, there are 48 parties that are parties to the GPA. But we have to take into account something that is frankly between us, we have to take into account into discussion. And it's that many countries negotiate GPA accessions purely for political benefits upon joining. And afterwards, they don't really implement GPA standards and obligations in practice. So what are these commitments and how can this affect actually the overall outcome of GPA? So one of the main pillars of the agreement are the non-discrimination provisions. In comparison to the GATT and GATS, what the GPA does, it actually groups the MFN and the national treatment provisions in one article. What does this mean? It means that it goes beyond, as it provides non-discriminatory treatment not only for goods and services or a combination of goods and services in procurement, but also for the suppliers. So in government procurement, it's important not only to prevent discrimination based on the origin of the goods and services, but also on the origin of the supplier. Why this is? This is because what we wish to achieve with the GPA is actually enhance the pool of competitors and open or market access for foreign competitors in local procurement markets. So one of the GPA is a really modern and flexible agreement. It has been renegotiated last time in 2012. And one of the main things that it has one of the new novelties is actually transitional measures for developing and least developed countries found in Article 5 of the GPA. So within these transitional measures that are available to this set of countries, we find, for example, price preference programs, offsets, phasing additions, higher thresholds, or deferred implementation. But we have to take into account that although we have these transitional measures, the implementation of such is not automatic. There are key aspects that have to be taken into account. So first, the possible uses of these measures taking into account the development needs of the country. So there has to be a justification or a need for these transitional measures to be actually taken into account or to be implemented. So for example, these are implemented to provide for a period of adjustment for sensitive sectors, or for the completion of ongoing or intended liberalization of a sector. Once again, what we can see is sectors. It doesn't mean that it's broad. It has to be applied for specific sectors or specific parts of the industry in a country. Second, the implementation period is not limitless. So we have a time period or a time frame of 5 years for LDCs and a time frame of not exceeding 3 years for developing countries. What does this mean? It says that the time frame shall not exceed 3 years, meaning that it's actually pretty much recommended that they do not go up to 3 years, that this time frame for developing countries should be less than 3 years. And last but not least, the most important aspect that has to be taken into account for transitional measures is that these measures are subject to negotiations during the accession process. What does this mean? This means that these measures must not be implemented afterwards. These implementations must be presented during accession negotiations. They must be discussed with the other GPA parties, and they must be cleared by other GPA parties at the moment of the approval of the final offer. So, for example, saying that it's not in line with GPA to actually amend the legislation or the procurement legislation towards applying discrimination measures after accessions, and there are risks associated with that. So, within the framework of the GPA, what's possibly next according to the GPA rules? So, each parties can actually modify the coverage of their offer. They can modify the coverage within the GPA. They can remove entities. They can add entities. That's really positive. So it's actually what most GPA parties seeks for, actually to parties to increase coverage vis-a-vis other members. But they also can withdraw or remove entities or coverage from the agreement. So any proposed measure needs to be notified to the GPA parties. This is a must. I think for the case of the current law, this notification has not been done yet. So it's something that needs to be done. And it is one of the obligations within the GPA. So after the notification of the proposed measure, and I mean proposed, so it has to be before it's implemented, not afterwards. After the proposed measure is notified, other GPA party has 45 days to object the measure. Within the time frame, also GPA parties can request some consultations or arbitration procedures to the GPA committee to facilitate resolution. If this doesn't work, the GPA party that wishes to implement such measures, for example, or not measure or modify some of the annexes or remove coverage or withdraw coverage from a GPA, they, after 150 days, they can implement the measure. However, after this is done, the other GPA parties are allowed to retaliate. What does this mean? They mean that they can withdraw substantially equivalent coverage. So for example, if a country withdraws a set of entities from their annexes, then other parties can do the same, and there is no, and this will not be inconsistent with the GPA rules, because this is actually allowed for. And lastly, if there's no resolution or no settlement, parties that see or parties that think that the measure are inconsistent with the GPA obligations can actually go to the dispute settlement body and request consultations, and if this doesn't work, then actually request establishment of a panel to resolve this within the framework of the WTO. So let me just, let me just conclude that measures that seek to protect the domestic industry are really important and are to some extent allowed. However, this has to be carefully designed, especially in light of existing international commitments, as they could create a negative precedent for other economies. And in this sense, they would erode the very intention of signing trade agreements, and more specifically, in this case, the very spirit of the GPA, which through trade liberalization, its provision on non-discrimination and transparency, it broadens the set of potential suppliers, and in this sense, and in this way, it attracts more product services diversity, it expands the pool of competitors, enhancing competition and obtaining value for money in return for each taxpayer's money. Thank you very much.
Thank you very much, Antonella. I have a very brief question. So do you understand correctly that there are no success stories of modification commitments under the GPA?
Mm-hmm. Yes, exactly. So I want to say success stories because, as you know, most of the cases are not alike. So there are differences that have to be taken into account, and even the small difference make a big effect on actually the decision that has to be taken by the panel or by the AB. So I wouldn't wish to compare earlier cases with this one, but what I would like to say is that it's really difficult to bring a case justifying these measures under the WTO framework, and especially under the existing GPA rules and obligations for Ukraine.
Thank you. And another question, as for notification of proposed measure, yeah? So the draft law, is it a measure seen under the GPA, or it is so where the notification obligation occurs when before the draft law actually is published at the very first reading, or when or before the draft law is going to be approved at the very final stage of legislation process?
Well, each country actually can decide on when it should be notified. It can be before it has brought to, it's a draft bill, so it's not implemented yet. And it can be actually done after it was the first reading. But most importantly, it will be interesting if it was actually notified before that, when the project was to be presented to the parliament. Because as you know, like in most of the cases, there are committees working on the projects, and these regulations are already being worked on, and it's a proposed regulation, so it should be notified at this stage rather than later. Why? Because then we can have the input or at least like discussions. Of course, it's not at the place of other GPA parties to tell Ukraine why they should act, what they should say or not in their legislations, but since we're working we're working under a multilateral framework, we have international obligations, it's really important to at least open a channel of communications and see how we can improve this proposed regulation, or if there are any ways that are especially less trade restrictive to ensure the same goals as this proposed legislation.
Thank you. Thank you for your response to my question. So, colleagues, dear participants, we will give some time for the questions after Kseniya's presentation. So now I'm giving floor. I'm transferring with pleasure the floor to Kseniya Smyrnova.
Thank you, Olesia. Thank you, Antonella, for your speech, and I would like to thank you. And I'm very glad to join UBA Trade Committee on this screen. So, from my point of view, so we saw the situation from the point of view of GPA and WTO system and all those commitments. From my side, I would like to speak more about EUAQUI and all those commitments and the point of view of European standards of public procurement and how it is reflected in the draft law. I will shift this question, so I will leave it for our conversation then afterwards. I will not speak on detailed on the norms because we are all well known on all these documents, but I will just emphasize all on two main key points. First of all, we should assume association agreement concluded between EU and Ukraine. I will not speak in detail about this agreement, but I would just to stress that one of the fields with a very strict commitments on regulatory convergence in legislation, it is about public procurement. Public procurement clause, I would like to say in such a way, such a complex of norms that included in the agreement, in association agreement between EU and Ukraine, can be characterized in a very strict obligations, commitments. And I will emphasize on the most important issues in it. First of all, in the core text, not in the annex, but in the core text, we will find the major principles that should be contributed within this regulatory convergence of legislation. First of all, transparent, non-discriminatory, competitive, and open tendering to sustainable economic development. And the main objective is the effective reciprocal and gradual opening of markets of two sides, I mean, Ukrainian and European sides, respective procured markets. Moreover, these clauses in agreement envisaged mutual access to public procurement markets on these principles and on the principle of national treatment at national, local, and regional levels for all public contracts, concessions in the traditional sectors, I mean, as well as utility sector. So we can say that utility sector is also emphasized specifically in agreement. Moreover, as I said about the regulatory convergence of legislation, I would like to say that this field, this sphere of relations belong to the progressive approximation of public procurement legislation within the EU public procurement acquis. So we can distinguish main four principles that are written in the core text: non-discrimination, equal treatment, transparency, and proportionality. Moreover, this agreement consists one more peculiarity, specifically in the public procurement sphere. And I would like to stress on it, because due account within the process of legal approximation that we are going on, due account shall be taken of the corresponding case law of European Court of Justice within the process of implementation of acquis, public procurement acquis, in national legislation of Ukraine. So of any modifications of EU acquis occurring in the meantime also should be taken into account in this process. So we are speaking about the better access to non-EU procurement markets within the regulatory convergence as a specific legal instrument that is provided in it. Moreover, I would like to stress, and I think and I'm sure that you know about the recent decision adopted by the Association Committee that was adopted in May 2018 concerning the roadmap on public procurement convergence regulatory approximation of legislation with a very strict items and very strict paragraphs and of directives of EU acquis that should be implemented in Ukraine. So, moreover, in the text of agreement, we can find another principle of effective reciprocal opening of respective markets that should be attained gradually and simultaneously. It's another very interesting point because these markets should be opened simultaneously. So, but in the same time, even in the core text, we can find another very interesting legal reference. We can find a
Colleagues,
can you hear me?
yes, now it's better. The connection has been broken for a couple of seconds. Yeah.
Can you hear me now?
Yes, now it's better.
Yes, I'm back. I don't know, something happened.
No, it happens at the
Yeah,
virtual meetings.
Okay. So I stopped on this issue that all these norms and all these principles and framework principles, they apply to contracts above value thresholds that is written in the EU directives. So we are speaking about the second my key point. So what are these thresholds and what are the major issues that included in the directives? So what is it? EU public procurement acquis. So of course we are speaking about the directives. We know that there are 7 directives dedicated to the general and sector-specific sectors of public procurement. From public sector, utilities, concessions, defense and security procurement, utilities, remedies, and so on. So there are 7 directives adopted in the EU. So all the sphere, the complex of national implementation of these directives on the level of national legislation of member states, we can assume as a whole are key. The EU directive is a piece of legislation that sets out the goal that all EU member states must achieve. This is another aspect that we should take in mind. The EU directives that regulate public procurement are based on principles of equal treatment, transparency, and competition, as well as other EU treaty provisions, I mean founding treaties, and principles that aim to assure this equal access to contracts. So there are 3 major principles: equal treatment, non-discrimination, and transparency. But at the same time, at these major common principles and values, we can find some exemptions. Certain contracts or entities are exempt from the directives. The most common exemptions include contracts below the thresholds value, contracts with technical and artistic constraints, contracts that protect exclusive rights, and contracts that involve specific activities in the utility sector in some geographical areas. I can say that this is an exhaustive list of exemptions of the contracts that could be exempt, that could grant the exemption from the general common principles of EU directives. The directives on government procurement are really very detailed. Unless a specific exemption applies, cover procurement EU above the stated thresholds values. The directives specify rules about everything from common procedures, thresholds, to remedy mechanism and standards. And all contracting authorities in the EU must strictly obey these rules. It is important to keep in mind that the legal force of the national law in each member state supersedes that on the EU directive. Of course, we can use some comparative legal analysis while using national legislation of member states, how they implemented the directive, but we can use only one norm, only one level of these norms, the EU directives. Directives specify the ultimate goal of national laws, but not how to achieve that goal. We know it as for sure as for general principle for EU law. Transposing directives into national legislation can be difficult, since national legal systems differ and member states do not always interpret directives in the same way. And these can lead to slight coincidence in national laws among EU member states. What about exemptions? Among all those 7 directives that strictly regulate the public procurement sphere in different sectors, while analyzing all these directives, we came to the conclusion that EU does not impose so-called by EU preferences, except when the value of the contract is below the stated thresholds and does not rise cross-border interest. That is the major rule of conduct in the EU. Member states must not include bi-national clauses in contracts that discriminate against other member states. The only one exemption we can find in Article 85 in the Utilities Directive, so-called Utilities Directive. This is Directive 2014/25. This is the only one example where we can find in Article 85, and this article allows EU contracting authorities in applicable sectors, only in applicable sectors such as water, energy, transport, and postal services, to reject non-EU bids where the proportion of goods originating in non-EU countries exceeds 50%, or give some preferences to the EU bid if prices are equivalent. While analyzing other directives, I mean in public sector, concessions, defense and security procurement, amending and review procedures in public procurement, we couldn't find such a clause of exemption on this by EU clause. So the EU government public procurement rules apply to contracts at or above a certain value. And these strict thresholds are written in these directives. When contracts are at or above the EU contract threshold values, the procedure and advertising obligations set out in the relevant directive apply. And this is the very strict rule. And this directive and other 6 directives that comply in the EUAQUI, they are really strict, explained in the recent roadmap on the implementation of public procurement in Ukraine. So we can came to the conclusion as a third, my key point. So what is the way out? What is the way out? Pragmatic protectionist approach versus international commitments. I mean, in this sphere, EU commitments based on EU-Ukraine Association Agreement. Of course, we should take in mind about thresholds. While implementing and while using legislative mechanism on implementation of acquis in Ukrainian legislation, we should take in mind the specific legal technique. The directive is obliged only to the main goal of this directive, but not the way how to achieve this goal. The second, my point, that we should take in mind all those figures, data that included in directives as a threshold value criteria for the implementation. Of course, we can take in mind another example in a parallel. In the sphere of M&A and control and concentration, we know that in EUAQUI there is a regulation with a very high financial criteria that should be implemented within the association agreement, EU-Ukraine Association Agreement, and these financial criteria, they should be implemented. We know that since 2015, Ukrainian national legislation also was amended with a more enhanced level of financial criteria, while clearance on concentrations, I mean mergers. This is one of the way out, because our Ukrainian national thresholds or financial criteria are much more lower than EU standards, than EU approach, because of the different assessment of the markets. Internal market and Ukrainian national markets are different from their figures. So taking in mind principles and those framework commitments that are strictly regulated in international agreement, with a very strict mechanism of monitoring of these obligations and fulfillment of these obligations, we really should take in mind the legislative process and how these amendments should be passed in the Parliament and what are the consequences on it. I think that on this point, I will stop here, and I'm really open for your questions. Thank you very much.
Thank you, Kseniya. So may I clarify your main idea? So your suggestion is that it is a good idea to align the competition, let's say the conditions of competition, the public procurement markets within Ukraine and EU. So there is logic and maybe an economic rationale behind this. And this is actually what the authors of the draft law are seeking. But on the other hand, there is this issue of thresholds. So this is what should be fixed in the new actually, and in the new text of the EU FTA, EU-Ukraine FTA. Should it be raised at the agenda of the Association Committee?
Moreover, Olesia, you are absolutely right, but one more idea. We are speaking about not only thresholds, but we are speaking about the subject matter directive. So we are speaking about these only one sphere of exemptions that it could be, that all these localization clauses could be included. It is written only in utilities directive. So we are speaking about only one sector: water, energy, transport, and postal services, as if we compare it with the EU market, with the EUAQUI. And about thresholds, of course, and of course, this issue with thresholds is this question is really negotiable. With this question, the negotiation should be started with the European party, with the European side, where it could be included. I think it could be included, and it could be decided on the level of the Association Committee decision. I mean, in the trade configuration, because it's really connected with trade. So I think this is the question of the competence of the EU-Ukraine Association Committee. So firstly, these questions should be raised there, and it should be decided there. And after that, it could be reflected in national legislation, in amendments.
Perfect. Actually, we have reached this point of the seeking a kind of solution for to find the balance between content and objective of the draft law. So thank you, Kseniya, for sharing your thoughts. And I see actually, colleagues, if you have questions to Antonella and Kseniya, this is the very right moment to address them. I see Slava Opejda in audience among our participants. It's my colleague, and actually Slava's topic is subsidies. So what do you think, colleagues? Maybe Slava will briefly comment. Do subsidies are at stake? I mean, do local requirements in this draft law, do they raise potential anti-subsidy investigations, and can these local requirements just trigger the subsidies program in Ukraine? Antonella, what do you think?
Well, I think it's, I wouldn't discount the possibility, but for me, from my perspective, I see these issues sort of obtaining to the government procurement rules. And these I see as rules are actually relate more to non-discrimination issues within the framework rather than subsidies or helping subsidizing sectors or industry. Of course, it can also develop into these, but for the time being, considering the draft law and the current proposal, I see it more under a perspective of government procurement measures rather than subsidies. Of course, this doesn't say that it could not, in time, affect affecting the same manner as a subsidy will affect the industry and exports in that sense.
Thank you very much.
Can I also add from the perspective of the EU law on this, the same question? So when we're speaking about subsidies, we know that for Ukraine, this is another very challengeable and vulnerable sphere that is already introduced in Ukrainian legislation. I mean, state aid to undertakings. And from this point of view, from another point of view, just we can analyze it in parallel. So all of these local clauses could be assessed from the point of view of the control on state aid. Finally, I really can share with you I'm not sure that everybody is really aware on state aid rules. But from this point of view, private sector, using the norms and using provisions of association agreement that strictly specify public procurement sphere and as well state aid in the field of the interpretation by case law of the European Court of Justice. And this issue could be really very, very challengeable for Ukrainian enforcement system. But this issue could be concerned with the state aid.
Thank you for your valuable comments. So colleagues, Slava, are you here? Would you like to comment? Okay, I'm not sure, maybe Slava or other participants you can just type your questions or comments, please do it, and we will continue the discussion on any aspect after all the speakers have opportunity to present. So yeah, if we don't have any questions on the trade block, let's move on. So Olena, happy to give floor to you. And I hope you will shed some light. So whether it is doable, actually, if we are talking about aligning the conditions, it's a good point, but is it from the practical point of view, is it actually possible, at least in the way how the drafters see it? So the floor is yours.
Thank you, Olesia. Thank you, colleagues, for your previous very interesting remarks. And as Olesia said, I work with this part of localization law, and I will try to show it from more like a practical perspective and how we are going to live if it's going to be adopted. I will share my very brief presentation. Just a second. You should be able to see it, right? Do you see it? Yes. Okay.
Yes, we see.
So it's my topic. I said that like introducing localization public procurement. So it's practical, purely practical perspective. I'll start from very general information of the status, because something very interesting has been happening in Ukraine for the last couple of months, I would say, because this issue has been on the top of public procurement discussion for a long time, but within the last couple of months, it became a huge issue, and everything started moving really, really fast. So right now we have, if we're talking about the status, we have two documents actually, which are trying to regulate the localization part, and they are not in line with each other, unfortunately. They have like significant discrepancies. The first one is the one that we have discussed, is the draft law, number 3739. As you all know, it was passed through the first reading in July. it's really fast. I mean, it was published, I think the first draft was published end of June, and then everything started moving really, really fast. And the other document is the draft resolution of the Cabinet of Ministers, which was published actually earlier than the draft law on the website of the Ministry of Economy. But it tried to make amendments to public procurement without actually making any amendments to the public procurement law. And if we're talking about the Steering Bureau resolution, you can see that people have been discussing it. Really, it's been interest. People had like certain interest in this resolution. You can see this is information as of today from the official website of the Ministry of Economy. So we have like 386 comments. And then we can see there's a huge number of people that support the draft resolution, and then there's a very, very little number of people that are not in favor of the localization resolution. And one of the major topics that has been surrounding localization discussion is actually specific issues with potential corruption-related matters. Even if you can see that even the National Agency on Corruption Prevention that was established a couple of years ago in Ukraine, they reviewed both the documents, and they say they contain a number of corruption causing factors. So basically it means that significant changes would need to be introduced. And as the most recent update, you can see that as of August 17th, 2020, one of the political parties, they have voiced this publicly. They said they made 2,150 amendments to the draft law. So I do believe that it's not available yet. The amendments are not available. The draft law for the second reading is not available yet as well. But I do believe that when it will be published, it will be a completely different document. We'll see a completely different document, and it will be very interesting to review. And I do think, and I do hope that a lot of issues that were raised, even from the trade perspective as well, will be taken into consideration. Now, as for the most recent information on the law, there's Ukrainian part of Ukrainian business that suppliers and manufacturers that are really for this law, appears to be for this law. But I do believe that they haven't read it with their lawyers, because they will face some very specific practical things that they will not be able to go through. So I do believe they need to talk and read the document with the lawyers. So if we're talking about the draft law, we can see I tried to do it like in two columns. The first one is what is being proposed, and the other is what potential issues are we looking at. And first of all, and I think that's my favorite, is definition of the localization level. And there's this reference to the prime cost. This is like a dead end for any suppliers, because nobody, and any manufacturers, because nobody wants to show the prime cost. This is like commercial. This is confidential information, and no supplier will be able to disclose the price structure, because this is just not how the competition, and this is not how the market works. The other one, this is not even closely related to localization, but there's some movements to include certain exemptions, but I think we'll move through this. To make it shorter, I would say that the next point that it's very important for me, and I do believe it will be very important for the whole Ukrainian market, is confirmation of the localization level. What the law is suggesting is that the Ministry of Economy will have this right to confirm the localization level. The law does not address how it's going to happen. They say there will be a special resolution, but if all of us that have worked with Ukrainian authorities, they know that they are rather bureaucratic. And if we say that in order to participate in some kind of public procurement tender, we need to provide a confirmation that is being issued by the Ministry of Economy, I think this will be a practical issue for most of the manufacturers, because this is an administrative procedure which cannot be controlled by the manufacturers. And this leads to potential corruption-related issues, because you will not be able, this is not an automatic procedure. This will not be an automatic procedure. and the confirmation will be a huge thing for any participants in public procurement. The other point is the list of the goods subject to the local level requirement. Even though the list, I think most of you went through the draft law, the list includes only 88 or 89 positions. However, in reality, it covers, like, I would say more than a couple hundred goods, because within each position, there's different types of goods. And basically, you will need to get this confirmation for each specific type of goods. It's not only 88, 89. So the manufacturers and the producers, they need to realize that this is the reality. If this will be adopted, this is how they will have to work through. And there's the other thing on the specific localization level percentage, which will be applicable to each, for the group, there's different percentage. It's still, like for me, I cannot explain. I don't even have any closest thoughts why this specific percentage. For example, why for one type of product it's 20 and for other it's 40. But the problem and the potential issues here with the specific percentage is whether Ukrainian market will be able to satisfy the suppliers' needs. Whether we really can produce like 40% of specific locomotive or car or whatever, whether we have the capacity, whether we have the necessary factories in Ukraine and plants, we can satisfy this. Because I do believe there will be issues as well here. Moving forward, so this is the law in the nutshell. And you can see that the list of potential issues, even if this is very, those are the issues that are on the top. And the list of these potential issues is there, quite big. And that's why I do believe that the draft law, even if the Parliament and the Cabinet Ministers and our government decides to move forward, needs to be revised significantly. We'll have to see those 2000 amendments. Following that, we'll be able to say whether it's okay or not, whether it will. But as of now, from the practical standpoint, it appears that it will paralyze the whole public procurement procedures for this specific types of goods. And if we move forward, we'll see that. Oh, sorry. So the other document, very interesting documents, is actually the CMU resolution. And I think that the first thing that should be pointed out that it provides for completely different approaches to the law. So we have the CMU resolution that refers to the manufacturers, and we have the draft law that refers to the potential bidders. So I do believe that if the government, if our legislative organs decide to move forward, they need to get in line both documents and decide which approach to take. What should be pointed out is that this CMU resolution does not introduce amendments to the draft law, even though it tries to amend the whole procurement structure. And the legality of such approach is still questionable, because according to our legislation, the any amendments to the procurement procedure can be made only within the specific law. So the CMU resolution probably is not the correct instrument. And from here, what we have in the resolution is that localization requirement is introduced as non-price criteria. Because according to the public procurement law, you can have, when you're deciding on the potential bidders, you have the price, it can be like 100 price criteria or non-price criteria. So actually localization is proposed as this part of non-price criteria, which specific Ukrainian entities, public entities, will be obliged to use. And the same way, when we go, why we are saying that this indirectly restricts competition, because based on this CMU resolution, only those manufacturers which actually have factories in Ukraine and can show Ukrainian localization part will be able to receive confirmation of localization and use it as a non-price criteria in any tender procedure. So basically, even if Ukrainian Ukrainian goods will be more expensive, Ukrainian companies will be obliged to buy them because their price will actually be reduced by this non-price criteria, which, for example, non-resident companies or the companies who are just incorporated in Ukraine will not be able to use. And then the list of equipment is completed. It's not completed, but slightly different from the one that was listed in the draft law, and it's raised a certain question, I guess. Here we have the same issue with the prime cost and the price of imported parts, because any manufacturers that would want to participate and obtain this confirmation from the Ministry of Economy would have to provide information on the prime costs and the prices of imported parts. As I said, as with the law, this kind of contradicts the whole setup of competition, and the manufacturer will not, I don't think that they will be happy to disclose this to anybody, even to the Ministry of Economy, because it's a confidential information for any market. And I guess the most interesting part with this document is that the Ministry of Economy has the right to consider your application within 30 days. So you apply, you get your confirmation within 30 days if you're a manufacturer. But sometimes the tenders, like the whole tender procedure in Ukraine, the minimum time frame for the procedure is 30 days. So basically, you will have to apply before the tender is actually opened and before any tender procedures even started. The question whether if I'm a manufacturer, I would think, do I really need this if I'm not sure whether the tender will be open? So it seems more logical to do this after the tender procedure was initiated. So, and yes, the localization formula, there's like a whole formula that refers only to, mostly to the prime cost without any references to the actual sale price. And that's why I do believe that it appears that this document raises more issues than it should be. So I guess my general view and my general recommendation on all this localization things is that if our state decide to move forward with this issue, they do both documents need to get aligned, and they do need to make it work from the practical perspective. So I guess that's it from my part. Sorry.
Thank you, Olena. Thank you for your presentation, and we are really happy that we have managed to combine both trade and these, let's say, corporate blog, but it's the practical blog. Yeah. My question is whether it is actually possible to calculate the feasible localization level that would meet the Ukrainian industry's capacities, presuming that we can do it. I mean, Ukraine can do it, like in view of trade commitments and so on, just they move on. So is it possible now to calculate, or it is an open question?
I would say it's an open question, because when it comes of calculation of this localization formula, you need to understand that you would have to calculate it for each specific spare part, for each specific little goods. And from the practical standpoint, I can see, for example, how big manufacturers and big factories go to the Ministry of Economy. For example, they produce like thousands. And if they would like to use this criteria, or they would need to confirm, if they're participating in tender, they would need to confirm localization level. So they would have to go through this procedure for every little piece of equipment, and it just doesn't seem doable from practical standpoint. So I do believe there should be some mechanism, but it needs to be investigated in more depth. The way it's now, I think it will paralyze, as I said before, it will paralyze just everything.
Thank you. So, dear colleagues, dear participants, do you have any questions? We don't have the questions from our audience. I will remind that our meeting is streamlined now in YouTube, and it is the record will be available at the UBA site. So if anybody who is listening to us and hearing us now have any further questions or will come up with some questions after the meeting, you can contact our experts. And yeah, let's hope they will answer you within the restraints they have. Yeah, so please think about questions. If not now, you still have an opportunity to contact us later. I have come out with another questions to Antonella a bit later, but at least I have this chance. What about the crisis of the DSU? Okay, we see that indeed the draft law now as it is, it violates WTO GPA commitments of Ukraine, and like frankly speaking, but isn't it the WTO dispute settlement crisis as an incentives for the WTO members to a bit, well, feel more scope for policy autonomy beyond the WTO commitments? Let's say this, put this way.
Yes, definitely. The crisis of the DSV is something that has to be taken into account. However, we also have to be taken into account that currently the AB is a part of the dispute settlement body that's under that's restricted and it's not currently taking in new cases. So, for example, in case there is this policy or this measure or the law on localization is actually adopted, and one of the other GPA parties decides to bring this to the WTO forum. So the first step will be to, under DSB or the dispute settlement understanding, is to actually open consultations. And this is a period of 60 days where they have consultations. And if these are not successful, then a panel is established. The panel is still working, and all of these new disputes are still working, are still being investigated, and are still being discussed within the DSB settlement. So that means that any issue that happens here still can be brought to the WTO. So this is going to what's going to happen is it's going to take, at least because of all the delays that are going on, and to have a panel decision, I presume it's going to be a longer time. But it's something that still can be done, and it's still some sort of pressure that exists on this side. So what happens actually, and that could be an issue, is if the panel provides a decision in this case, and Ukraine is not happy with the decision because let's say that the panel decided that yes, these measures are incompatible or inconsistent with the GPA rules, and then they have to be amended in that sense. What happens is that Ukraine can actually appeal this to the AB, and since the AB is not working currently, what will happen is what's currently known as appeal into the void. So they can appeal, but there are not the number of arbitrators that are there to actually discuss this issue. It's not there. So actually, the last point where they can go effectively is only until the panel report. And so what I mean is that yes, there is in that sense still the DSB is still working, but unfortunately, if they want to go all the way not with the decision of the final report, then it's going to be really difficult to obtain a decision with the AB unless all these issues are solved now that we are having a discussion for the next DG. So there are a lot of changes going on at the WTO. So hopefully we don't know what's going to happen, but it can be that the DSB can be working again by the end of the year. We don't know that, but that's something that can happen. So in the meantime, it's not going to reach that stage yet. So any party, any GPA party that has an issue can actually go and record to or go and present consultations to the DSB.
Thank you. Thank you. So dear participants, do you have any questions? Okay, you can write text us and message. So I will just, you have a couple of minutes just to think of it. So
Olesia, while participants are waiting or some formulating some questions, may I ask something?
of course.
You know, it's a very interesting question of the Brexit and how this issue could be taken into account, and what would be the influence of Brexit in GPR and all this system. Of course, I have an answer from the point of view of Ukrainian relations and the consequences of the relations with Ukraine, but what are the consequences for the WTO system of this? How do you think, Antonella? What are your ideas on it?
I'm muted. Sorry, can you repeat the last section?
I mean the Brexit. I mean the possible influence of Brexit on the further WTO and GPR, and so what are the consequences of Brexit? How maybe can they make some derogations, and what are the perspective from this point of view?
Well, actually, that's pretty, that issue is pretty much being discussed within the GPA committees. That the GPA committees are being held every 3 to 4 months at the WTO. Currently, because of the COVID pandemic, so these are not taking, the last one was in July, and it was only in online virtual mode, and only just a couple of issues were discussed. But before that, the Brexit issue has been an issue that has been discussed at least since 2018, beginning 2018, like definitely. So the issue here is that the difference with the other agreements and with the UK and the GPA is that actually within the GPA, all of the EU members are members to the GPA, but as EU. So that means that you have 48 parties, but more countries or more economies. So what happened here, it was a pretty legal question, actually. What could happen when the UK goes out? So currently this has been discussed and this has been negotiated. So the current issue is, what happens now is the following. So we have the UK. The UK is leaving the EU. So until the transition time is over, they're going to continue being a party to the GPA under the EU, but they are currently negotiating their reinsertion, or not their reinsertion because they were never as UK, but their accession as UK in its own right. So it's going to be the 27 countries plus and the UK as a party. So it's going to be 49 parties when this finalizes. So one of the first steps that has to be done was last year, actually, UK had to request to become an observer to the agreement, because since they were leaving and they were not a party yet, they needed to be in the committee meetings. So they had to request observer status. And that was actually a pretty funny situation, because a party coming now as an observer, but yet happens, one of the effects of Brexit. So currently they're under negotiations, and the issue is that, okay, everyone wants UK to be part of the GPA, but since they're leaving the EU, now they're saying, okay, UK, you can come into the club again, but please tell me, how are you going to improve the offer, or how are you going to improve your commitments vis-a-vis the commitment that you already have with the EU? So we need something better, or we need something, at least it's not the same, but at least it's more attractive for us to actually make this GPA club interesting for all the parties. So that's the current situation with the UK.
Thank you. So many good points you raised, Kseniya, and thank you, Antonella, for answering. Yeah, it's what actually we seek to do during our meetings, to cover very up-to-date topics and go beyond the issue, actually, and to see it in complex picture. So dear experts, dear audience, thank you very much for being with us, for joining us. Again, the record will be available and open for actually, so hope to see you at our future events. Yeah, I would remind to our participants who will listen us that we have launched actually the Facebook and Instagram accounts where we post the updates on trade and trade law news regarding Ukraine and world, and it also addressed the current WTO DG selection process inter alia. Yes, so please subscribe to our accounts. And if you have any ideas, I mean, members of the committee and those who wants to join us, if you have any ideas on further topics, please do suggest, and we are very open to elaborate on it. So thank you again, Antonella, Kseniya, Olena. Very much appreciate your efforts and your time, and hope you with this pleasure and inspiration you will come back to your to your project and to your loved ones. So have a nice evening, everybody, and stay safe and healthy.
Thank you.
Thank you.
Bye-bye.
Thank you, Antonella. Thank you, Olesia. Thank you, Olena. Have a
Thank
nice evening.
Have a nice evening.
Have a nice evening as well. Bye-bye.
Bye-bye.
Bye.